All right, we've made it through trial. We've given our opening statement. We've done direct examination. We've done cross-examination. We've admitted exhibits. Maybe we've dealt with an expert or two. We've had objections and we've had motions with the court. Now's the time to deliver the closing argument. That thing that you planned for first in case analysis, that you do last at trial. So what is closing argument? Closing argument is that moment where you take the evidence that has been admitted, the promise that you made in opening statement of what the story would be, that you've kept through the facts that you brought in. You take those facts and you connect them to the law and you interpret the facts. And you have to interpret the facts based upon your understanding of human nature, common sense, and what most folks would think really happened in that situation. It means you comment on witness demeanor. You talk about the reasonableness of a belief, the validity of evidence. In short, you argue what this stuff means. And you're spending a great deal of time applying the law that you know the judge is going to give in jury instructions to your discussion of the facts. Because you want through that application of law to facts for the jury to decide the case your way. So how can you get in trouble in closing argument? Well, if you don't argue, if you just retell the story, you wind up giving an opening statement during closing argument. And that, by the way, is the most common mistake that young advocates make. So how do I do this effectively when I close? Well, the first thing that I do is that I have to be confident in my position. And I can show confidence in a couple of different ways. One is through body demeanor and physicality, and I've talked about that before. Another is through tone of voice. How fast I talk, how loud, how softly. The pacing of my words. I vary that pace. And I vary the pace to fit the emotion or the argument that I'm making about the facts or about a person. For example, I've got a witness on the stand that we didn't believe, but the witness's credibility is key because if the jury believes him, I've got a problem at trial. Members of the jury, you heard Robert Hightower discuss what he did that night. Now I want you to stop and think for a moment before you decide whether or not to believe this man. Because what do we know about him now that the police didn't know that night? Well, we know that he called the guy who was murdered that afternoon on his cell phone. We know that he and his brother have been involved in drugs in the past. And we know that he had a .45 caliber pistol in his hand by his own admission the night of the murder. And we also know something else that's kind of interesting. His brother, the police chief, is the person who interviewed him that night. Not Officer Baxter White, not Detective Morris. His brother shows up at the scene to talk to Mr. Hightower. I wonder why. I wonder why. You should wonder why. Because that interaction of the police chief with this single witness during this trial, during that investigation, helps us understand why the actions of the police are so below the standard that is necessary. The decision was made to convict Miss Alexander of the murder of her husband within 3 hours of it having happened. And it just doesn't fit, and you must acquit. All right. Now, you see how I attacked Mr. Hightower there? How I used circumstances from the case, State v. Alexander, to show that this guy's just not credible. He's just not believable. Confident in your position. I've talked about arguing facts and law. There's something I haven't mentioned, though, and that's dealing candidly with your weaknesses. If you don't have the evidence, you don't have the evidence. And it doesn't do you any good to act like you do. You don't want to be the lawyer who makes the argument and then the opposing counsel gets up and says, let me tell you all the things they didn't tell you. Again, State v. Alexander case file. The state has a problem. Got a couple of problems. One is that nobody saw the murder that night. So you got to deal candidly with it. Members of the jury, you've heard all the evidence. You've listened to the information. You know that we don't have an eyewitness to this murder. I'd love to have an eyewitness for you. I'd love to bring someone in here who could tell you what they saw, but I didn't plan the time and the place and the location of the murder. The defendant did. And they chose carefully. They chose a time when no one else was available. But although I don't have an eyewitness, and although I don't have a confession, I've got a lot of pieces of circumstantial evidence. And if you flip those pieces over so that you can see the colors, and you align them properly, the picture becomes very, very clear. This woman murdered her husband. Let's talk about how she did that. And then I segue into my discussion of circumstantial evidence, and the circumstantial evidence that's in the trial. You deal with the weakness, and you deal with it in a way that makes sense to the jury. You draw on the jury's common sense. The jury must always feel like what you say works. And you'll know when the jurors feel like what you say is work, because you'll catch one going, you get a nod of the head, or a look down at the ground. Now you don't try to read them, but using common sense works. It's effective. The other thing that you want to do is you want to structure this presentation. Use those concepts of primacy and recency. Talk about the best piece of evidence first and the best piece of evidence last. Put your weaknesses in the middle. Go through the evidence. Tie it to the law. Make the argument, and then give the call to the jury for what it is you want. You have to have the strength of character to tell the jury what it is you need them to do. You can't leave them to figure it out on their own. Till next time, I'm Charlie Rose. Take it easy.